Well, good afternoon, everyone, and welcome to this final, somewhat graveyard shift. And it's musical chairs, I'm afraid. In place of Thani Al-Thani, you've got me as the moderator. My name's Thomas Williams. I'm a partner and barrister, and I'm based at Sultan Al Abdullah and Partners here in Doha. I specialise in arbitration. I also lead my firm's practice before the International Court and Regulatory Tribunal. We've also got Arighna Ghosh, who is taking the place of H.K. Suresha of Masin, who can't be with us this afternoon. But anyway, it's very good to be here. The way this session is going to work is that there are going to be 4 rounds of questions posed to each of the 5 panelists who I'm going to introduce now. The first is Julian Cohen. Julian is a barrister and arbitrator specializing in construction, engineering and energy disputes. He's based in Hong Kong, as I understand it, but he spends a lot of time in Qatar and elsewhere in the Middle East. We have Michael Dullaghan. Michael's an executive director at DMD Consult with experience in contractor, client and consultancy roles. We have, as I say, also Arighna Ghosh, who is the director of operations of Masin in Qatar. He's a very experienced delay and quantum expert in the field of construction and engineering disputes. We have Ahmed Abdelbakey. Ahmed is a partner at Resolve International in Dubai in Egypt. Again, he regularly appears as an expert in engineering and construction disputes. Finally, last but by no means least, Ghada Karbon. Ghada is the founder and managing partner of the law firm here in Qatar that bears her name. She regularly sits as an arbitrator with particular experience of sports-related disputes. So I'll begin, if I may, with the first round of questions. And I have a question to you, Ghada, which is, what do counsel expect from experts?
Thank you, Thomas, for the kind introduction. And of course, I would like to thank the organizers for organizing such an important event for Ciarb, especially Dr. Nasser Al-Adba and Saad Hijazi as well. And I'm thrilled to be a part of this panel. We are here today to discuss an important topic that affects the very foundation of our legal system. The expectation that arbitrators have for expert in arbitration cases. As you all know, arbitration is a dispute resolution process that is often used as an alternative to litigation. In an arbitration case, the arbitrator's decision is based on the evidence and testimony presented by the parties, as well as the opinion and recommendation of expert witnesses. To ensure that the arbitrator can make an informed and fair decision, there are certain expectations that arbitrators have for experts in arbitration cases. First and foremost, arbitrators expect experts to be knowledgeable in their areas of expertise. This means having a deep understanding of the subject matter of the case and being able to provide informed opinions and recommendations based on sound reasoning and principles. Secondly, arbitrators expect experts to be impartial and unbiased. Experts must be able to provide objective and independent analysis that is not influenced by the interest of the parties or any external factors. Furthermore, arbitrators expect experts to be transparent and forthcoming about their qualification, experience, and methodology. Experts must be able to explain their analysis and conclusion in a clear and understandable manner. In addition, arbitrators expect experts to provide their opinions and recommendation in timely manner. Experts must be able to meet deadlines and to be available for hearings and other proceedings as needed. Finally, arbitrators expect experts to act with highest level of professionalism and ethics. Experts must uphold the integrity of arbitration process by being honest, fair, and toward all parties involved.
Ghada, thank you very much for that. Moving on to Julian, slightly different question. What do arbitrators expect from experts?
Thank you very much. The first thing is that I'm going to approach this from the position of an international arbitrator, from a common law style arbitration. And I say common law style because I think in this region, and I've been working in this region since 2009, even in civilian seats, even in Sharia seats, you often have much more of a common law style process on big construction engineering disputes, even though that is not necessarily what the home jurisdiction would normally do. So you would often have, for example, two experts, each party having their own, rather than a tribunal appointed expert. As an arbitrator, my job ultimately, therefore, is to look at the dispute, listen to the dispute, hear the dispute, understand the dispute, and then render a decision. So what do I want from an expert? What I want is a trustworthy guide who can help me understand what the issues are, the specialist issues, the complex issues, the technical issues, what they are, how to think about them, how to look at the material. Because if you put yourself in my position, if you have two good quality experts, both of whom have a slightly different opinion or very different opinion on the underlying dispute, I still have to look at those two sets of reports, listen to that evidence, think about it, and work out where it takes me. So the role of the expert, I think, is much more of the trustworthy guide. I entirely endorse the points that my colleague has just made. And in addition, I think you want an educator. You want someone who can explain to the tribunal about their expertise, who can, when you read the report as a tribunal member, you can follow it. Often there are hidden assumptions or missing steps in the logic or in the explanation, so that then the tribunal gets, okay, A, B, hang on, I don't understand how we got to E. So I think you want someone who can articulate and explain where they've got to. Someone who is independent and impartial, but much more than just advocating, is there to explain and help and educate. And in the end, so that the tribunal, when it's looking at the complex issues, where there are differences of opinion and legitimate, real differences, starts to understand how to think about that and to make an informed and appropriate determination. So I think that's what I would want.
Julian, thank you for that. Michael, what is a shadow expert, and how does a shadow expert differ from a tribunal-appointed or party-appointed expert in an arbitration?
Thank you. A shadow expert is an expert that one party to the dispute retains to advise and assist the legal team during an arbitration. The shadow expert's role is to help the party prepare the case and to provide a counterpoint to the evidence presented by the tribunal-appointed or the party-appointed experts. The key difference between a shadow expert and a party-appointed expert is that a shadow expert is not disclosed to the other party or the tribunal. The shadow expert works behind the scenes, providing advice and guidance to the legal team, and their work remains confidential throughout. In contrast, a tribunal-appointed expert is appointed by the tribunal to provide an independent and impartial expertise on technical matters relevant to the dispute. The role is to assist the tribunal in making its decision, and their opinion is disclosed to both parties. The role of the party-appointed expert is to provide expert evidence on behalf of one of the parties. Their part is to present the evidence in a way which supports their party's case, and their opinion is not independent or impartial as they're appointed by one of the parties. In summary, a shadow expert is a confidential expert who advises and assists one individual entity. A tribunal-appointed expert provides independent expertise to help the tribunal, and a party-appointed expert offers expert evidence on behalf of one of the parties.
Thank you very much for that. Question for Ahmed now. How, in your experience, if at all, do experts participate in the preparation of the pleadings, by which I mean the statement of claim and the defence and so on? That's the question which I've got in front of me. I might just tailor that and say, would your answer be different if it were a memorial-style pleading as opposed to a common law pleading?
Thanks. Yes, it will make a difference, but before saying what is the difference, let me start with saying how experts participate in the pleadings. So as Mike mentioned, shadow experts might participate heavily on the pleadings. They might help lawyers to draft. They might help lawyers to draft the submissions, to build the arguments, to put the technical matters inside the statement of claim or defense or all the submissions. That will be an advisory expert or a shadow expert, as Mike mentioned. When it comes to independent experts, they may also participate in the pleadings. Lawyers goes to an expert, an independent expert in the early stage to get an independent view. So maybe the lawyers, even before filing the case, go to an expert and ask for his independent view on the matter. And the expert can give the lawyer his independent view, so the lawyer can make use of that independent view either to change the arguments or search for more solid grounds or search for more solid documents and so on. Even in drafting the submissions itself, acting as an independent expert, we may participate with the lawyers. Lawyers goes to the appointed independent experts and they might ask his independent view also on the submissions. So before releasing the statement of claim, lawyers might share those submissions with an independent expert, ask them to get their independent opinion on the technical matters. So the experts might tell the lawyer, okay, this matter is, as an independent guy, is not going to be accepted for me. This argument, for example, or this part of the claim, when we speak about delay claims or quantum claims, is not calculated properly. It's not supported with enough documents. So all such independent views can be given to counsel as a participation of independent expert during the pleadings. And when we go even more in the pleadings, experts also play a role in the document disclosure and in all the proceedings. Going back to your question, how it's making a difference in memorial style or traditional style. I personally prefer the traditional style. Memorial style will require the expert to do all of the work without seeing all the submissions from the parties. From the first submission, the statement of claim, expert reports will be included in the statement of claim, fact witness will be included there. So I will not be given a chance to see what are the documents from the other side or what are the submissions from the other side or the fact witness from the other side. That applies for the memorial. So there is some disadvantage on that, but as well there is an advantage on the memorial style, where as experts, the key advantage for it is we are involved at a very early stage. So we don't come at the end where all the submissions is done and we have a huge volume of documents that we have to read and digest in a very short time. So that's the main advantage and disadvantage of memorial style when compared to traditional style. While in traditional style, Experts have all the documents, have all the fact witness statement in front of them before doing the reports. So all the documents might have been filed already. All the documents might have been available to the expert before he filed his own expert. I believe that is the main difference between the two approaches. That's it. Thank you.
Thank you very much indeed. I mean, I think the key is to get the balance right between guiding counsel and arguing the case, because as an expert, you can't argue the case for your client. And I think one has to recognize the boundaries. And some tribunals take great umbrage at experts who appear to be ventilating a case for their client. We had a recent case where the other side simply said, well, we have a time-based claim, but the critical path and everything else is going to be set out in the expert reports, and we took a point on this. And the tribunal said, well, you don't have a properly pleaded case. The role of an expert is to opine on the pleaded case. It's not to create the pleaded case later. You can't argue your case through the experts. Have you come across a situation such as that? And if so, how have you dealt with it?
Yes, it happens a lot. It happens a lot, and it's always a debate. It's always a dilemma and a difficult situation. Experts should be independent and impartial. As Julian mentioned, our main role is to assist the arbitrators, in explaining the technical matters and in putting an independent opinion in front of them. So arbitrators will not rely on my report if my report is independent. If the arbitrator found that I'm advocating or I'm giving an advice to the party appointed me, then he will not rely on my report, and accordingly I will not be of any help of him. So that's a very important point.
Yeah. Question now for Arighna, if I may. Do you think that the early participation of an expert in the process is an advantage?
Thank you, Thomas. Yes, the early participation of an expert is indeed an advantage. What this early participation actually does, this allows the particular expert to have a thorough review right from the commencement of the case and deciding the strategy of the claim being made. Of course, like Mr. Ahmed said, considering the independency, that has to be also taken into account. But however, what advantage this will do, this will allow for consistency in the position of the party right from the pleading stage throughout the process. It is better to have that kind of a position rather than having to revise the claim based on experts' opinion at a later stage. Further, what this early engagement does, the expert, as an independent view, can again give views on what document is required for them to assess the matters in this entirety. There could be instances where the experts join the arbitration at a much later date, and for example, let's say after the disclosure process. So there could be a chance that that key documents which was required for his assessment may be missed out. When experts are included in the arbitration at an advanced stage, the timelines are generally restricted for the expert to carry out the analysis or assessment that covers all the documents available in a comprehensive manner. With early engagement and initial assessment available, the instructing counsel and the parties can take a decision on what all claims they need to take forward in the arbitration. How this helps? This helps to identify the claims where significant lack of documentary evidence can be excluded from this bunch of the claims. This will allow the respective party to not only save time, but avoid unnecessary institutional cost of the arbitration. In doing so, there are some challenges which the experts also face, particularly on the documentation part. The volume of the documentation is too large when it is not being provided in a very identified manner. So at early stages, the party could not segregate those documents in a claim-wise manner. And therefore, there could be instances where all the claims which are decided may not be taken in the way it has to be taken up. The expert can also face challenge of maintaining focus on a particular case, because if we are appointed at a very early stage, the period of the arbitration extending long, it could become a little difficult for the expert to have focus what he has read through the matter in the early stages of the arbitration. And therefore, this could be one more disadvantage in an early appointment.
Arighna, thank you. Moving on to the second round of questions and back to Ghada. Ghada, what are the key considerations an instructing counsel should bear in mind when preparing instructions for an expert?
Thank you, Thomas. Owing to the technical issue that the dispute may rise, the parties may decide to appoint arbitrators with the requisite expertise and rely solely on its expertise. Alternatively, or in addition, first, each party may wish to appoint their own experts. Second, parties may jointly agree to appoint a single expert. Third, arbitrators may wish to appoint a single expert instead of the parties doing so. And or arbitrators may wish to appoint a tribunal appointed expert in addition to the party appointing experts. As part of the fundamental of arbitration, it is one of the right of the parties to submit evidence and be heard, and if such evidence requires an amount of expertise, the parties have the right to appoint an expert witnesses. It is for the party appointing an expert to direct its own appointee as to their assignment and to instruct them on any direction given by the arbitrators concerning the exchange of views and any meeting to be held with their counterparty expert. This may include directions for the expert to meet in order to seek to narrow and differences of opinion, and to prepare a joint report identifying the issues on which they have agreed and the issue on which they disagree, with an explanation as to how the differences arise. The issues on which agreement has not been reached will normally be dealt with by cross-examination on the two experts jointly, known as witness conferencing, to be followed by question put by the arbitrators. The parties are offered the right to ask further questions of the expert following the arbitrator's questions of the experts.
Ghada, thank you for that. Moving to Julian. Julian, in your experience, is it common that instructions to an expert are disclosed to the tribunal? And if so, what are the points to consider in preparing instructions just to meet that eventuality?
Thank you. I mean, I think there are two different things there, at least, that we could be talking about. Instructions could simply be, at a fairly general level, what is it that the expert has been asked to do and what to look at. Or it could be something much more detailed. In some countries, some common law countries, not all, for example, all of the instructions, all of the communication between a lawyer and the expert needs to be disclosed. My experience is that is relatively rare outside one or two jurisdictions. But in terms of what is the task the expert has been asked to do, that is common, and indeed it's, in my view as a tribunal, essential. If I'm trying to understand what the expert's evidence is, to understand the issues underlying it, the evidence, the material in front of me, I need to know what the expert has been asked to look at, both in terms of what the questions are and also the material. I mean, if, for example, the expert has not been shown all of the relevant documents, that's something as a tribunal that's very useful to take into account. So I think in some level...
It's good cross-examination material as well.
If I had a different hat on, I might agree. As a tribunal, I'm interested in the final result. But you're right to say that the testing process, because cross-examination has two elements to it. There's the sort of tactical or strategic advantage that a party tries to take, but there's also helping the tribunal genuinely to understand the issues and materials, and so therefore that process is helpful. In terms of what should be in there, I mean, firstly, from a tribunal's perspective, you want it to reflect what has been asked of the expert, rather than a fictitious question. The second is it's helpful when that is framed, where possible, in a neutral phrase. Of course, each party will want to frame the issues in a way that it helps them, and that's perfectly legitimate. But to the extent that the experts are able, both in terms of the instructions and in how they deal with those instructions, to really get at the meat of the issues underneath, that's very helpful. So what's helpful? The first thing is to reflect the reality of what's been asked. Secondly, to ask the expert in their instructions good questions and give them access to all of the relevant material in play. I'm not sure, Thomas, with that.
No, it does, Julian. I haven't seen instructions disclosed in this part of the world. Certainly in England they tend to be. But in any event, an expert in his expert report will rehearse, in summary, in any event, the instructions. And sometimes that can be problematic, and it can be good cross-examination fodder, frankly. Because if it's quite clear that the expert has been instructed effectively to construct a case, then you can cross-examine he or she, him or her, quite hard on that. Michael, what are the benefits and drawbacks of using shadow experts in arbitration?
Okay, if we start with the benefits, I think first and foremost is shadow experts bring expertise and knowledge to the case, which can assist the legal team in preparing their case and identifying any areas of weakness in the other party's case. The second point would be confidentiality. Using a shadow expert allows parties to receive advice and assistance without disclosing their strategy or evidence to the other party. This can be particularly advantageous when the parties are concerned about confidentiality or particularly sensitive information. The third benefit, I would say, is it's cost effective. A shadow expert can be cost effective compared to retaining a party-appointed expert, particularly when the dispute involves complex and long-standing technical issues. In terms of the drawbacks, I think a key one is inequality of arms between the parties. Using a shadow expert can somewhat create a perception of unfairness, mainly if the other party is unaware of their involvement. Secondly, there's a lack of transparency in using a shadow expert, and it can be seen as an attempt to gain an unfair advantage in some way, which can potentially erode trust between the parties and the tribunal. The third part is a shadow expert can potentially manipulate evidence, which may wrongly create or suppress evidence in the arbitration proceedings. The fourth point is there's a potential risk of proximity of the experts and a risk of direct contact between a shadow and an independent expert, where the shadow expert could contaminate or improperly influence the independent expert. And the final point is, in some particular jurisdictions, there's a risk of discovery of using a shadow expert, and the instructions could become disclosable.
Michael, thank you. Moving to Ahmed. Ahmed, what in your view makes an expert report a good expert report?
That's a difficult one, but in general, taking from what Julian and Dr. Ghada said, arbitrators are looking for experts to assist them. So at the end, if the expert report succeeded in assisting the tribunal, then it's a good report. We are seeing a lot of very detailed expert reports, very detailed analysis, but not well structured, not well written, so it doesn't assist the tribunal. So I would say that even if the analysis done in that report is good, the report at the end is not a good report. In simple terms, a good report is a report that assists the tribunal in reaching a decision. And to do a good report, the report should be written in a simple way. Experts are appointed to give their opinion on technical matters that the tribunal might not have such knowledge on that technical matters. So it should be written in a language that arbitrators can understand, in a simple language. It should be well structured, so arbitrators, when reading the report, can go through the reports in an easy way, see where to look, and if they have doubts about any points, they can easily reach to those points. Of course, the report should be objective and impartial. That is a key element which we repeat saying when we speak about experts. The report should also include what are the tests and the criteria and the methodologies that the experts have adopted. So to convince the arbitrators that you are the right guy to give him an expert opinion, you should mention to the arbitrator what are the criteria and the methodologies that you have adopted. You should mention all the facts. As an expert in your report, you should not omit any facts, even if those facts are against the client appointing you, because your duty is to the tribunal. So mentioning all the facts, mentioning all the documents that you have seen in your report is very important. Referring to any international practice or international standards in reaching your opinion and conclusion is also an important element of your reports. So that's it. In simple terms, good reports that are reports that assist the tribunal in doing their duties.
Thank you. I think in general terms, it's important for experts to stick to their brief. I mean, if you're a quantum expert, you shouldn't be talking about the law reliability. It's amazing how many do. And speaking with my advocate hat on, you spot this, and then you cross-examine them, and your questions start off in this sort of way. I mean, you'd agree with me, wouldn't you, that you shouldn't be talking about matters of law? Absolutely, no, I shouldn't be talking about that. And you'd also agree with me, wouldn't you, that you shouldn't be talking about matters of liability? Absolutely. And the reason for both of those things is because if you did either of those, you'd be overreaching and you'd become an advocate and lose your independence, and they readily agree to that. And then you trap them by taking them to the paragraphs where they do exactly what they've expressly just disavowed, and it all becomes horribly unstuck. Arighna, can you add anything to what Ahmed has just said?
Yeah, while most of the points Mr. Ahmed said are required, there's one important point which can be added. As an expert, it is required for the expert to be proactive in seeking the documents, because it is one of the most important part for them to formulate the expert report. So they have to seek the documents properly from the instructing party. And based on that, what could be relevant to assess the claims, it has to be done in a very impartial manner. So this is one point which I would like to add to that.
We're on now to the third round of questions. You'll all be delighted to hear, because there's only 4 of them. A question to Ghada now. Ghada, what is the process of appointing an expert? And do you tend to interview potential experts prior to appointments? And if so, what are the key aspects you look for in the expert in terms of their characteristics and approach during such an interview?
Thank you. The process of appointing an expert in an arbitration case typically involves several steps. And while some arbitrators may choose to interview potential experts prior to appointments, it is not a common practice. The first step is to identify potential expert who possesses the necessary knowledge and experience to address the specific issue in the case. This may involve researching and reaching out to individuals or firms who specialize in the relevant field or industry. Once potential experts have been identified, the parties may exchange names and resumes and discuss their qualification and experience. The arbitrator may review the resumes and make a determination as to whether a particular expert is suitable for the case. In some cases, the arbitrator may choose to interview potential experts prior to their appointment. During these interviews, the key aspect that the arbitrator may look for in the expert include knowledge and experience. The expert should possess deep knowledge and experience in the relevant field or industry. Impartiality. The expert should be able to demonstrate their ability to remain impartial and unbiased. Communication skills. The expert should have strong communication skills and to be able to explain complex concepts in clear and concise manner. Availability. The expert should be available to participate in the arbitration process as needed, including attending hearings and providing reports or testimony. Professionalism and ethics. The expert should uphold the highest level of professionalism and ethics, including complying with all applicable laws, regulations, and ethical complying rules or conduct of codes that govern their work. Thank you.
Ghada, thank you. If you were, as part of the interview process, to interview a potential expert and he or she was to say, I haven't actually previously been a testifying expert, would that as a matter of principle put you off instructing that person, or would you be prepared to give them the opportunity to take the mandate on? I only mention that because I've had 2 experts in recent years who we've instructed and they hadn't before testified, and they were brilliant, indeed far better than people that have done it far more often. I just wondered what your thoughts were on that.
Well, I totally agree with you. Sometimes we have to put steps for the expert and to try to liaise with them, at least to have a good outcome that will serve our case.
Ghada, thank you. Moving on to Michael. Michael, what criteria should be used to select a shadow expert?
Thank you. First and foremost, expertise. The shadow expert should have the necessarily knowledge and expertise to advise the project team on the technical issues relevant to the dispute. Second of all, confidentiality. The shadow expert should be able to maintain the confidentiality of the appointment and maintain discretion to protect the interests of the party that's retained them. The third point, I'd say, is availability. The shadow expert should be able to provide advice and assistance as needed throughout the arbitration process. And to the second point is, shadow experts can effectively assist parties in several ways. First of all, they can provide specialist expertise. Second of all, they can evaluate evidence at an early stage, which has been presented by both parties, and provide an opinion on the strengths and weaknesses. This can help the parties assess the credibility and the reliability of evidence and make better informed decisions. Next, they could assist with the presentation of evidence for use in the arbitration, including preparing reports, conducting conferencing, and preparing for cross-examination. This can help the parties present their case more effectively and efficiently. Next, they can provide independent advice. And finally, they can assist parties with settlement negotiations outside of the arbitration process.
Michael, thank you. Moving on to Ahmed. Ahmed, what's your experience of document disclosure with the opposing expert at the initial meetings prior to preparation of joint reports?
That's very important. The document is a key element for any expert report. And in many cases, I'm putting my delay expert hat. In many cases, the documents that you need to do your analysis is not included in the pleading, like the progress reports, the program, and so on. So you might request the party appointing you to get those documents from him, not from the pleadings. And you should as well allow the other experts to have the same documents. It will not be fair if one expert has a set of documents and the other doesn't have. It will not assist the tribunal. It will not be fair. The tribunal will always seek that both experts have the same pool of documents. Both experts should share the document with each other. So all the documents available, experts can make use of them to get better results. But of course, that need to be regulated through the tribunal. The arbitrator should put some regulation for that, the time for sharing the documents, the method of sharing the documents, and so on. But generally speaking, I strongly prefer sharing documents between experts, of course, before joint reports, or even in the initial stage of the proceedings, to allow both experts to have the same pool of documents in giving their opinions.
Ahmed, thank you. Julian, different question. Presentations by experts before they give their evidence, good thing or a bad thing?
Thomas, before I do, can I go off piste for a second?
Sure.
And just sort of respond to your point about experts who haven't testified before. Often, my experience is they can make the best experts testifying.
I agree.
And for that, the reason is that there is often a huge time gap between writing the reports and testifying, at least in certain styles of arbitration. Often the work has been done by people behind the scenes, and someone who is coming in to do their first arbitration as a testifying expert is really going to get into grips with that. And often the people who are at the top of the tree are so busy, they come in, they perhaps were on top of the material at report stage, but they haven't done enough prep. So in fact, often someone coming in who has more to prove, more terrified, more keen to do a good job, actually does do a good job. In terms of presentations, of course it's going to depend. I mean, partly it depends on your tribunal. Hopefully you've got a tribunal who has read the material on top of things so that they don't need an executive summary, they know what's coming up. But presentations can be helpful in three ways. One, sometimes to signpost, because particularly in a construction engineering dispute where the material is very complex, it's quite often helpful for an expert to signpost to the tribunal, these are the 5, 6, 7, 8, 9 things that I think are important for you to listen to whilst there's questioning going on. The second thing is as an ability to educate or make sure that the tribunal understands some of the technical issues that underlie, if there are technical issues, so it can be a teaching opportunity. And thirdly, and this is something that puzzles me over the 35 years that doesn't get done well in many arbitrations, how many times would you expect an expert's opinion to be slightly different to their report, having listened to evidence that's come out from factual witnesses? And the answer is you would expect, I would have thought, from common sense perspective, most times, I mean, something always happens at a hearing with witnesses which should impact on the expert's opinion. Very few experts, in my experience, take the opportunity to update their report. Now, I mean, whether presentations or some other form is the right format, we can debate. But again, the ability to say to a tribunal, I said this in my report, I've heard what's happened over the last few days, and the impact on my report of that is this, I think is important. Of course, there are dangers in presentations. One, it can introduce new material that shouldn't be there, and the tribunal has to be very alive to that. It can be used, whether consciously or sometimes unconsciously, to start changing cases. So one has to be aware of that. And also, the most single expensive time of the proceedings is a hearing, and therefore a presentation that takes up time and doesn't add very much is just a waste of money. So it's going to vary.
Julian, thank you. Arighna, you just heard what Julian said about expert presentations. And picking up a point that he made, what are the key issues that you as an expert would consider when preparing a presentation for a hearing?
Yeah. One of the key points which the expert should keep in mind is to provide references to the expert reports from where the opinion is being formed. This is useful for the tribunal during the cross-examination and the expert assessment, and removes any doubt on the content of the presentation, that it is different from the opinion which is formed within the expert reports. As an expert opinion, a thoroughly referenced presentation could even be used by the tribunal as a ready reckoner when preparing the arbitral award. All the information produced by the expert throughout the arbitration stage spans in various documents like individual expert reports, joint experts reports, etc., which generally runs into hundreds of pages. A presentation at the time of hearing often offers the expert a chance to summarize and explain his opinion in a concise manner using one single document. What it does, this helps the expert to also simplify some of the complex matters in the arbitration. It helps the expert to highlight the areas of differences in assessment of the experts for ease of understanding of the tribunal. It is generally accepted view that visual aids create a significant impact in the minds of the viewer. If the expert is able to prepare and present a presentation that is visually simplifies the complex technical matters, that would create an impression in the minds of the tribunal, having more impact than written words in the expert report. That would help the expert get across his point of view with regards to the assessment more effectively. Yeah.
Thank you. Yes, I'd agree with that. Thank you very much. And now we're on to our fourth and final round of questions, and a question for Ghada, if I may. Ghada, what is your experience of challenging the expert evidence of the opposing party during an evidentiary hearing?
Thank you. In an arbitration case, it is not uncommon for the party to challenge the evidence presented by the opposing party, including the expert testimony. During the evidentiary hearing, the parties have the opportunity to cross-examine the opposing party's expert, challenging their opinion, methodology, and findings. Challenging the expert evidence of the opposing party can be a complex process, and it requires a thorough understanding of the relevant facts and legal standards. The party challenging the expert must be able to demonstrate that the expert opinion is unreliable or biased, and present alternative evidence or expert testimony to support their opinion. It is important to note that the challenging of expert evidence of the opposing party can also be a strategic decision. Depending on the circumstances of the cases, it may be more effective to focus on presenting one's own evidence and expect testimony rather than attacking the opposing party's evidence.
Thank you very much indeed. Michael, how can the use of shadow experts contribute to the efficiency and effectiveness of the arbitral process?
Thank you. First and foremost, I would say informed decision-making. The advice and assistance of the shadow expert can help parties make informed decisions on complex or technical issues that require specialist knowledge. Second, I would say it helps with the preparation, and the shadow experts can assist the parties and their legal teams prepare their cases, identifying strengths and weaknesses as they go, and developing effective strategies. The third point I would say is the reduced cost. The shadow experts can reduce the costs of the arbitration by avoiding the need for parties to engage party-appointed experts, and by providing an efficient and cost-effective means of obtaining specialist advice. The fourth point is time savings. In my opinion, the involvement of shadow experts can reduce the time required for expert reports, expert conferencing and cross-examination through the provision of key and salient information early in the process, thereby speeding up the arbitration process. And finally, better outcomes. The the use of shadow experts can lead to better results by ensuring that the parties and arbitrators have the access to the best available expertise and by improving the quality and accuracy of expert evidence.
Michael, thank you. Ahmed, we've touched on this before, but what is the role of an independent expert? And why are independence and impartiality so important?
Generally, the role of independent expert is to assess the tribunal and giving expert opinion, impartial expert opinion to the tribunal. The expert might be appointed by the tribunal, as Dr. Ghada mentioned. It might be a tribunal-appointed expert. It might be a joint expert appointed by the parties together, or it might be a party-appointed expert. I think impartiality and independency is a key element of the expert reports and the expert role. When it comes to a tribunal-appointed expert or a joint-appointed expert, this is not a matter of question. It's less questioned. But when it comes to a party-appointed expert, the independency and the impartiality is highly questioned. I believe everybody in the room have dealt with clients who does not understand how to convince the client that you are paying the expert and he's an independent expert. So the expert should make that very clear to the client appointing him. The expert should make it clear to the client appointing him that he should provide independent reports to assess the tribunal. If his report is not independent, simply the tribunal will put his report aside or will give it very low weight, and that will not help the case and will not help any of the parties. So independency should be very, very clear, and it should be made clear as well to the clients that payment of the expert fees or being liable to pay the expert should not be related by any means to the independency of the expert himself and the role the expert is playing.
I couldn't agree more. Julian, finally from you, if I may, before I ask one final question to Arighna. Again, we've touched on this, but what is the main benefit for tribunals in having experts before them at an evidentiary hearing? And I suppose say that doesn't duplicate previous answers. You might focus on the evidentiary hearing point as opposed to just the general benefit of having evidence before them in paper form.
First of all, again, I'm looking at this from the perspective of a common law style set of proceedings. Because, of course, if you're in a civilian world, and both are different, neither, I think, are better or worse, they're just different. But from a civilian perspective, of course, by the time you get to the evidential hearing, it's like this final question, fairly short. It's about the final opportunity to clarify things, whereas from the common law style, of course, it is the main meal. So it would not be uncommon. In fact, probably arbitrators should arrive at the start of the evidential hearing with a very open mind as to which way they're going to decide, where the evidence is going to take them, what the experts, what their views of the experts are. So with that in mind, the evidential hearing, one, brings the whole dispute to life. It's when you start really being able to explore what are the issues, how much credibility does the expert have they looked at the right things, can they explain how they've got to the decision or their opinion that they've set out, and it's your opportunity as a tribunal to make sure you really do understand the technical or the complex issues that the experts are addressing. And often I find, to the extent that I have any particular thoughts in mind at the start of the hearing in terms of where the issues are taking us, they vary and they change, they develop over the hearing. So it's very much the time for the tribunal to really start understanding the depths of and the complexities so that they can make a proper and an informed determination at the end. I'm not sure whether that quite answers your question.
No, it does, and I agree. And it brings it all to life, and it allows it all to be tested in real time. And often, as you say, what appears in the printed page can be very different after it's been subject to cross-examination, and a good advocate won't open his case too high. He'll say, well, look, these are our claims, these are why we say the defences are bad and why our counterclaim should prevail, but I'm going to leave the evidence alone. I'm not going to talk too much about it because I don't want to reveal my hand for cross-examination. Then it all comes out, and the tribunal can stand back, and the forensic landscape of the case is then much clearer, and they can assess it. Arighna, just finally, hot tubbing, advantages and disadvantages?
Okay, it's an interesting thing. In most cases, hot tubbing and or expert conferencing basically leads to saving time, cost, leads to the tribunal having a deeper understanding of the complex matters involved in arbitration, and enables the tribunal to make simultaneous inquiries to the specific issues and understand how each expert formed their opinion and background behind the same. The advantages, in most cases, it helps the tribunal better understand what the expert agree and disagree upon. This streamlines the task of the tribunal, especially when it comes to matters that the experts agree upon. Hot tubbing, despite what the literal name suggests, it aims to create a relaxed environment for both the expert. This, when followed, will allow for greater cooperation and meaningful discussion, especially on matters which the experts agree upon. It also has certain disadvantages. One of the major disadvantages of hot tubbing is its effectiveness more or less lies on the quality of the queries and the questions which have been raised by the tribunal. If the tribunal is not well versed on the matters in the arbitration at the time of hearing, the questions during hot tubbing may not be relevant, and therefore the process would not be very effective. If the experts have a past history of, let's say, some kind of friction, then the sessions may not be entirely effective, as it would lead in a different direction, the issues which are being raised in the arbitration. This approach requires the experts also to be well versed with skills of debating, since this involves considerable discussions. This is slightly a different requirement or skill compared to preparing reports or attending cross-examination. Finally, this is generally an increase in the time spent by the expert in preparation before the hearing, as he or she has to anticipate the questions from their counterpart and also prepare suitable responses for the same.
I'd agree with that. I mean, sometimes questions do arise for cross-examination which have been thrown up during hot tubbing. You've got to keep quite a careful eye on what's said. And sometimes it can be quite useful what the opposing side's expert says in hot tubbing, and you can pick them up on it. Anyway, look, thank you all very, very much indeed for bearing with us. Huge thanks to each of my panel members for their very valuable contributions. I know a huge amount of work has gone into preparing their responses to the various questions. Thank you for inviting me to step in. It's been a pleasure to moderate this. Thank you to the organisers for a really fabulous occasion. So that's enough from me. Thank you very much. Ah, I see. Thank you, Ciarb.
Thank you so much. So, as an expert, I have a question, and this question could be answered by two speakers, I think, Julian and Ahmed. The first question to the counselors, how they are selecting the best strategy for cross-examination, which kind of cross-examination people are normally prefer, and how to be selecting this one, because I have witnessed different styles as the panel was discussing, like hot tabbing and other various cross-examination types. The second question is to Ahmed, how to get ready for the cross-examination, specifically if it's hot tabbing.
I mean, in terms of your question, is your question more from the perspective of tribunal in terms of hot tubbing, or is it generally cross-examination?
Yeah, how the counselor choosing the best strategy?
I'd be interested in Thomas's view as well, but the reality is and I'm stepping away from my role as tribunal, I'm stepping into my role as advocate, all cross-examination has one of three aims. Either to get out material that the witness has that will help your case. The second is to show something that the witness or the expert says can't be right. Or the third is to cast general doubt on the credibility of the expert. So in that regard, you have to have a look at the tribunal, you have to look at the facts, the evidence, the expert's report. If an expert's done a good report, cross-examination should be relatively limited. If an expert's done a bad report, it's different. The one tip I would give is if I'm cross-examining, for example, a quantum expert, I will often look at the very, very small value items first, because of course everyone says follow the money, put the work into the big items, and you can often find very careless mistakes, therefore, in the very small items. That does two things. One, it unsettles the expert. Second, leaves the tribunal with this sense, if you're lucky, that, well, if they've been careless on the small things, what else is there out there?
That's exactly right.
I mean, one could talk for ages, and I'd love to, but I better not.
Okay, for the second question, how should experts prepare for the meeting and for the hearing and cross-examination? I would say generally experts should read their report one more time. It happens a lot that you draft an expert report and the hearing is a bit of time after that. So you should read your report again one more time. During the examination itself, my typical advice is to keep impartial. Don't jump outside your expertise. We see counsels, a lot of cases, asking experts outside their expertise and asking experts to give their opinion on that. As an expert, you should be giving your independent and impartial opinion to the tribunal on the matters that you have an expertise in. If the question is not relevant to your expertise, simply say it's outside my expertise, it's not in my report, so I could not assess the tribunal. The more important issue in the cross-examination, try to address the tribunal always in answering your question. Try to assess them. So even if the question is criticizing your reports, you should answer that question in a way to assess the tribunal. Clarify the matter to the tribunal, even explain to them what is the technical matters in question. Maybe repeat the question again in a simple way to explain it to the tribunal. So during all the hearing, during all the cross-examination, your duty is to the tribunal. So the best way to do the hearing and cross-examination is to assess the tribunal in understanding the matters that are mentioned in your report. Thanks a lot.
Good evening. Paula Qatar, KO International. Other than for reason of lack of independence or lack of impartiality, to what extent, and is it possible for a party to challenge the appointment of the tribunal expert for lack of experience or for irrelevant expertise? And in case the tribunal rejects such objection, what are the odds of that same party filing a second objection for lack of impartiality due to possible grudge or due to risk of grudge by that same expert against that same party?
I think lawyers should answer that question.
Well, I have to say, I've never come across that before. I mean, you're right. If there are independence issues or lack of subject matter experience, then that would be a ripe ground for challenge. There might be issues relating to language. If the individual isn't fluent in the language of the proceedings, you might want to challenge. I think it would be an uphill struggle to suggest that a challenge having been made and rejected would give reasonable grounds to apprehend that there might be some form of animus on the part of the witness, such that that in and of itself would give a further ground for challenge. That would be my view.
My name is Nagarajan. If the adjudication means dispute adjudication board in the contract, can the adjudicator can be taken as an expert or witness?
I believe it depends on how the DAB is structured in the contract and how is the contract provision of the DAB. If the DAB contains an expert who decides on the matter in an impartial way, an independent way, yes, I believe he can be called as an independent expert later on in the proceedings, because he will be doing an independent rule in both cases. But if the DAB allows that guy to do a mediation or represent one of the parties, then it might be difficult if to accept that guy as an independent expert later on in the arbitration. I'm not sure if the lawyers agree with that view or not.
I mean, my experience, again, it might be different if you're looking at it from a pure, proper civilian arbitration. From a common law style arbitration and the DABs I've been involved with over the years, it was rare. I don't think I've ever seen someone who was the independent expert on a DAB then turning up trying to give expert evidence, and I think it would be very, very unlikely that that would actually happen, but I wouldn't want to rule it out, and I agree it would depend in part on the DAB rules. The DAB rules, though, often provide that those involved in the DAB at the decision-making end can't give evidence.
Good evening, panel. Thank you for a very informative session. My question is addressed to Mr. Julian, and this is related with the situation where we have party-appointed experts. So when we've got a couple of experts giving an opinion on a single matter, and if you get a situation where the opinion from the expert is different, it's a bit different. So as a panel, how do you tackle that? As arbitrator, how do you tackle that?
I mean, that's the situation probably in most of the arbitrations that I sit on. You have two party-appointed experts giving slightly different views. What you have to do is, one, do your best to really understand what the technical specialist issues are. You have to follow and look at their evidence. Often in practice, if expert one sets out steps A, B, C, D, E, F, so it's logical and you can understand it, whereas the other expert maybe has A, B, C, G, H, and there's missing bits, so you can't quite get your head around how they jumped. They might have been right to jump, their logic might be correct, but because you as a tribunal can't follow that, that's an issue. So you're really trying to do a proper job. If I gave one war story, I had an environmental appeal in Hong Kong many years ago, and we had the world's expert on marine dumping at sea. He had developed environmental systems used in the North Sea. He was the UN expert. He is the person that governments, or at that time, called up if they had an environmental problem. He was absolutely the world's expert. And he had a dreadful time in the witness box, and his evidence was completely destroyed, wrongly. But he was destroyed because he was so much the expert's expert. He was used to going into a room and saying, the answer is this. And everyone would say, well, Professor X says that, that's what we want to hear. He wasn't able to explain to a tribunal the baby steps of logic So that the tribunal didn't really understand what he was saying, even though he was actually correct. So a lot of the evaluation comes down to, can the tribunal really understand what you're saying? Which is why an expert that sets out everything in logical order often has an advantage. But you also have to test it against the evidence. You also have to look at, did they stray into areas they shouldn't? Did they, if they spoke about law when they shouldn't, did they recognize and say, hang on, sorry, you're right, I shouldn't have dealt with that? Or do they try and defend themselves? Because in the end, what you are trying to do, and the reassuring thing for me, having now been sitting as an arbitrator for well over a decade, is most arbitrators take the job very seriously. So you really are trying to get the right result. But it's hard, because of course you've got an expert, precisely because it's often outside your own expertise.
Just to add to what Julian mentioned, I believe when experts have different views, the joint reports are very helpful in those cases. Joint reports are made to allow experts to try to reach agreements to points, and as well list their disagreements and justification why they disagree, which will help the tribunal at the end to focus on the disagreement points. So if both experts could agree on the joint report on 6 items out of 10, then the tribunal rule will be to look on the 4 items where experts have a dispute or where experts have disagreements. So joint reports is a key document in terms of disagreements between experts, or to highlight what are the key points that the tribunal need to consider in the hearing or in the cross-examination and so on.
To decide the disagreement.
Sorry, you need to repeat again.
If you just use the mic.
Instead of joint report from these 2 experts, can the tribunal appoint one more expert to decide to resolve the disagreement?
Yes, it happens in many cases that when tribunal is not convinced, or when experts have totally disagreed in all the points, the tribunal might appoint an independent expert, and he will be a tribunal appointed expert.
Yes, I mean, a decent tribunal will read the expert reports and they might say, well, hang on, actually, we think that a fundamental issue which has been pleaded isn't actually addressed adequately by the expert evidence. So we direct the experts to turn their mind to issue A, B, C, or whatever it might be. I've seen that happen. It's perfectly legitimate. And provided that the timetable can accommodate it and the parties have time to respond, well, then all well and good.
Good afternoon, and thank you to the panel. My question is for Julian and Ahmed. You have mentioned how important is the role of the experts in order to help the tribunal to make a decision. I would like to know how relevant is for the experts and for the experts' work the legal frame provided by the contract terms and the provisions in the contract in order to assess valuations or changes, and how relevant is as well the outcome of the disclosure of documents process. For example, where the tribunal has rejected that some documents are to be disclosed. Thank you.
Okay, from the expert point of view, of course, the contract is a document that the expert need to read. When we're talking about technical experts, for example, and not a delay expert, a technical expert, an expert who have been assigned to give a technical opinion on a matter, he need to read the specification, he need to read the drawings, he need to read all the contract documents to come up with his opinion using the contract provision and contract documents. So of course, the contract provisions and the contract document is a key element for the expert opinion. The second part of the question, if I'm not mistaken, you are asking about the outcome of the disclosure process. The outcome of the disclosure process is at the end, the tribunal decide which document the parties should disclose and which documents that the party should not disclose. Any document will help the experts at the end, both experts. So whatever documents have been disclosed in the disclosure process and the tribunal was convinced that this document is required for the expert to do his work or his duty, then that document would be in help for the expert to do his report and to reach to his opinion. Julian.
From a tribunal's perspective, firstly dealing with the disclosure point, I think it's going to be the expert has to address the documents or sometimes lack of documents that are available. But it's not for the expert to then delve into whether or not the tribunal should have ordered, should not have ordered, did order. All they can do is to look at the material. And on the contract side, unless you are a legal expert, of course, that if you're a legal expert, it's rather different. But if you are a quantum expert, a delay expert, then you need to be aware of what the contract says. So if, for example, the contract specifies that a retrospective analysis of delay is required, then of course you must do that. So it's the guideline, but it's not for you as an expert to start debating what the contract means. So if, for example, you're looking at delay and there is a debate between the parties as to how you properly interpret the extension of time clause and what sort of analysis is appropriate, a delay expert can say, well, if party A's view is upheld by the tribunal, then this would be my analysis. If parties B's view was, that would be my alternative analysis. It can set out the framework, but what it cannot do, what he or she cannot do, is enter into the debate as to how that contract clause should properly be interpreted.
I couldn't agree more with Julian. Time and time again, we see expert reports that solely deal with the instructing party's position on a pleaded case, pleaded issue. And you have a field day in cross-examination, absolute field day. And you say, well, what you should have done is you should have considered the alternative positions put forward by my client, shouldn't you? And they got nowhere to hide. So I absolutely agree with Julian. And again, it comes back to the key point here, which is about impartiality. It's ensuring that you recognize your proper role, which is to assist the tribunal. And if you're doing that, what you're doing is you're looking at what one side has said, looking at what another side has said, and said, well, look, ultimately, I want to guide the tribunal. And if the tribunal finds that party A is right, well, this is my view. And if the tribunal finds that party B is right, well, this is my alternative perspective.
Thank you so much for these insightful thoughts and discussions. So I would like to invite my colleagues in the board, Nurul Sabri and Arib Mahmoud, to just deliver the trophies to the panel. Please welcome them. Thank you so much. Now we will be moving to the closing session. It's not a session, just a few minutes of closing. So ladies and gentlemen, as we came to the end of the first Ciarb Qatar Arbitration Conference, I would like to express my sincere gratitude to everyone who made this event possible. So first and foremost, I would like to thank the chair of the Chartered Institute of Arbitrators, Qatar branch, Dr. Nasser Al-Adba, for his exceptional leadership, guidance, and support. Without his vision and hard work, this conference would not have been possible. Dr. Al-Adba's dedication to promoting arbitration in Qatar has been an inspiration to all of us, and we are grateful for his unwavering commitment to our case. So also I would like to extend my sincere thanks to His Excellency Sheikh Dr. Thani bin Ali Al-Thani, who unfortunately has been called on emergency matter, for his invaluable support for this event. His Excellency involvement in the conference underscores the importance of arbitration in Qatar and the region. Also, my thanks to Mr. Faisal Al-Sahuti, for his tremendous support to the conference and to the team. I would like also to thank our distinguished guests from abroad who participation has enriched our discussions and contribution greatly to the success of this conference. Your presence here today is a testimony of the growing of the importance of the arbitration in the international community, and we are grateful for your contribution. To the attendees, I want to express my gratitude for your participation and engagement. Your presence here today demonstrates your commitment to the advancement of arbitration, and we are thrilled to have had the opportunity to share the knowledge, ideas, and insights with you. I would like also to acknowledge and thank my colleagues on the branch board for their hard work and dedication, especially our organizing committee, which is I would like to invite them to the stage one by one and give them a clap our hands and congratulate them. I would like first to invite Nurul Sabri. Vanessa Malone. Adib Mahmoud. And Tamer Zaru. Their tireless efforts in planning and executing this conference have been integral to its success. Finally, I would like to express my heartfelt appreciation once again to Dr. Nasser Al-Adba and invite him to the stage for his outstanding support and leadership in making this conference reality.
We would like to thank Saad. He is the hidden soldier behind all of this. So clap for him, please.
I will ask the team to help me delivering one to the doctor for his tremendous effort on this one. So by this, we would like to say thank you all for coming, and hopefully we will see you next year on the next version. It's a good idea that we can all come to the stage to have a group picture. If you would like, please join us. We are all one team. We can come from both sides. تحت كمان, okay. Down also we can get more people, and on the stage we can get more people. Also, just to remind you that this conference certificate is an NFT, so please take a photo of the QR code outside, get your NFT to be memorized.
Very good.